Thank you very much, Alan. Let me start with some words of Yeats. Grant me an old man's frenzy, myself must I remake, till I am in Timon and Lear, or that William Blake, who beat upon the wall till truth obeyed his call. Over the years, my frenzy has been granted through many outpourings of contemptuous derision and spiteful bitterness, which were stimulated by Ian Callinan's appointment to the High Court. These outpourings will not be dignified by repetition here. What caused them? Malice or ignorance? Many of the outpourings occurred before Justice Callinan's career as a judge had begun or progressed very far. Some ignorance was inevitable then, for though Ian Callinan was well qualified for judicial appointment, there is no doubt that sometimes the well qualified turn out to be flops. But ignorance is no longer excusable now. We can learn the lessons of experience. It is time to obey the call of truth. In Australian conditions, Justice Callinan was a model judge in a court of final appeal. He arrived at just and sensible results. He employed efficient and orthodox techniques to achieve them. He carefully deployed all the talents he was born with and all the skills he learned from life. He brought many fresh perceptions to bear on the wide range of legal problems he examined. He was among the ablest judges ever to have sat in this country. Let me just make three preliminary caveats. The first is that my argument today is that Justice Callinan possessed key virtues. That does not imply that other judges did not, and nor does it imply that they possessed countervailing vices. This address is about Justice Callinan, no one else. Secondly, none of the information on which today's argument is based rests on hitherto undisclosed rumours or secret tittle-tattle or breaches of intra-curial confidence. The merit of the argument can be judged by anyone who's prepared to examine the published judgments of Justice Callinan and consult the recollections of those who saw him in court. A third caveat relates to cases, of which there are mercifully very few, in which Justice Callinan and I disagreed. Vanity and stubbornness compel me to say that when I praise his judicial performance, I'm not admitting that in those cases he was always right and I was always wrong. There are two key elements in his early career which should be stressed. One is that he studied law part-time, contemporaneously with articles of clerkship. Many people now think this is undesirable. On the contrary, as the careers of many able lawyers in earlier generations have demonstrated, the practice can develop discipline, concentration and skill in using whatever time is available to best advantage. The second key element in his youth was the period of 5 years he spent as a solicitor in a small firm, culminating in partnership. That was another valuable aid to professional success. It revealed the personalities of ordinary Australians and the problems of businesses, small and large, which they conducted. He was sworn in as the High Court judge at the age of 60. For modern times, that is an unusually advanced age. He was then in his fourth decade at the bar. He had developed an outstanding reputation as a senior counsel of formidable trenchancy in any court in the country and across most fields of law. He had become one of those counsel of last resort whose services are in clamant demand from the desperate because everyone else and everything else has failed. Apart from his professional success and apart from his second career as novelist and playwright and his third career really as scholar and collector of objets d'art that Nicholas Hasluck has mentioned, there was an additional career of sorts. In his youth, he showed cricketing skill as a batsman and leg spin bowler. One day, playing for the Queensland Colts, and therefore knocking on the door of first-class cricket, he battled grimly on a bad wicket for 20 or so. As he left the field, he was stopped by a small middle-aged man who squeaked in his high-pitched voice, "Well played, son." Thus spoke the biggest figure in Australian sport, a man who did not give praise lightly, the then-retired Sir Donald Bradman. That was the high point in anyone's career. Ian suffered a less glorious fate later in his career when bowling to Ray Lindwall famous fast bowler, but also a batsman good enough to make 2 Test centuries. The English man of letters and cricket writer Alan Ross said of him, "Medium-paced bowling is meat and drink to Lindwall, and he is a batsman of Rabelaisian appetite." The same was true of slow bowling. One day in a grade match, Lindwall scored a century in 4 overs or so, 1 or 2 of those overs being bowled by Callinan. That was astonishing hitting, even though the overs were 8-ball overs. But over the decades to come, Callinan retained all his skill. When the great Yorkshire all-rounder Wilfred Rhodes secured the return of the Ashes to England at the Oval in 1926 with his left-arm orthodox spin bowling, Neville Cardus wrote of him, "Rhodes, at the age of 49, fielding at deep third man, did not present a quite decent spectacle." Ian's career continued well past the age of 49. The spectacle was never indecent. The scores were well made. He repeatedly demonstrated the incapacity of modern players to cope with his flighted bowling. On the bench, he used cricketing examples to expound legal doctrine. He had one other long-term sporting interest, and that was tennis. Again, he played with considerable vigour, as his doubles partners sometimes learned the hard way. It's become a cliché, sourced in Social Duty, to mention the contribution made to the career success of a husband given by the husband's wife. In the case of Ian and Wendy Callinan, it would be a cardinal error to treat praise for Wendy's role as merely routine or perfunctory. She was fundamental and critical to his success. She was an expert on George Berkeley, Bishop of Cloyne. In prose which Yeats thought dripped with suave, glittering sentences, Berkeley propounded a philosophy of what has been called theocentric immaterialism. It saw the significance of the universe as lying not in its objective reality, but on the fact that it is experienced by minds. A biographer summarised it as being this: minds are involved both as agents and as principles, with the divine mind as the overall agent of the order within which created minds function. That difficult and subtle thinking was crudely characterised by some as the theory that the reality of the universe was just an idea in the mind of God. In his life of Dr. Samuel Johnson, James Boswell called Berkeley's thinking ingenious sophistry to prove the non-existence of matter and that everything in the universe is merely ideal. Boswell then recorded that he observed to Dr. Johnson that though we are satisfied his doctrine is not true, it is impossible to refute it. "I," said Boswell, "shall never forget the alacrity with which Johnson answered, striking his foot with mighty force against a large stone till he rebounded from it. I refuted thus." Berkeley was one of Yeats's 4 great 18th century Irishmen with Swift, Burke and Goldsmith, and Yeats wrote of him, "And God appointed Berkeley that proved all things a dream, that this pragmatical, preposterous pig of a world, its farrow that so solid seem, must vanish on the instant, if the mind but change its theme." Wendy's formidable willpower, coupled with a brain which could master the subtleties of the Bishop of Cloyne, made her a redoubtable ally of Ian's against his enemies. What assets did Ian bring to the High Court? He was likeable, courteous and correct, and those civilised qualities lent him nobility. For he was a patrician and is a patrician in the best sense of that word. He's one of the finest representatives of the Judeo-Christian cultural tradition modern Australia has to show, although the bar is admittedly not high. He had all the professional skills of the highly experienced trial and appellate barrister. They had been honed by the rude educative experiences to which silks can be exposed by their over-jealous juniors. Ian was once cross-examining in a case, on the fringes of which there moved a New Zealand merchant bank named Fay Richwhite. Ian's junior had never made it clear to Ian either the existence or the significance, if any, of Fay Richwhite. But the junior nonetheless felt moved at one point to whisper to Ian the indignant command, "Ask him about Fay Richwhite." Obediently, Ian asked, "Do you know a Miss Fay Richwhite?" The astonished trial judge, Mr. Justice Rogers, interrupted in his marked Hungarian accent, Mr. Callinan, she is not a lady, it is a merchant bank." Ian Callinan had a broad experience of life, and his novels are significant in this respect. They don't comprise a vast series with recurring characters interlinked by blood or marriage or class or clan and illuminating large parts of an entire society, like those of Balzac or Zola or Proust, but they do show much about modern Australian life. I've read all of them, and each of them has contained something new to me about Australia. His literary works also demonstrate a capacity for hard work, and that was a capacity which it turned out to be very necessary to a judge, who increasingly saw it as important to dissent or for some other reason to write separately from his colleagues. Each night in Canberra after dinner, Ian would abandon the legal problems of the day and turn to the play or novel currently on the stocks. Like the great Lazare Carnot in the French Revolution, he was the organiser of victory. But Ian's victory was not over the Austrians, but over that most dangerous and unforgiving of enemies, the fruitless and wasted passing of time. Unusually for an appellate judge, he had considerable experience of criminal litigation. Not only is that a highly technical field, but it raises basic problems of ensuring the fairness of trials. Like Justice Frankfurter, he saw procedural technicality, a punctilious concern with formal questions debated in dispassionate legalistic arguments, as a foundation of liberty against the state. He saw other foundations of liberty in Australia as resting on majoritarian democracy, as practiced by Australian political parties under the Westminster system, on a limited separation of powers, and on federalism, with its capacity to decentralise power and permit the making of local experiments to suit local conditions. And indeed, there are recurring reminders in his judgments that Commonwealth activity in fields in which the Constitution doesn't grant it legislative power does not destroy the role of the states. He did not believe that liberty rested on Bill of Rights provisions to be implied into the Constitution. In resolving particular controversies, he disfavoured broad, abstract statements of law. He preferred to formulate narrow propositions which were sufficient to resolve the issues arising out of the particular facts of individual cases, and which were therefore difficult to extend automatically or blindly or unnecessarily to other contexts. For Justice Callinan, among the key criteria of the rule of law, particularly so far as it did not rest on statute, were certainty and immunity from abrupt change. For him, the law conferred liberty on citizens to plan their affairs for their own benefit. He preferred accretion to revolution. He favoured legal development of a natural and foreseeable kind, not sudden rupture or brutal violence. Like Lord Devlin, he accepted that a judge-made change in the law rarely comes out of the blue. Rumblings will give warnings of unsettled weather. But even if there had been rumblings, he treated judge-made legal change very seriously as involving a traumatic drama. He certainly thought that legal change which was radical and sudden, effected without any preliminary warning at all, was alien to the common law system. He saw further it as being vital that the law be administered by judges who were independent of the state, independent of great and powerful bodies within the state or allied to the state, independent of particular litigants and their friends, and independent of each other. Some people think we have an inward-looking senior judiciary which perceives itself as a supreme elite, anointed by a benign destiny to enjoy the paramount power in government and to possess more wisdom and virtue and less fallibility or doubt than any rival to that status. Whether we do or do not have that elite, Justice Callinan did not evidence any urge to develop it or join it. One key asset he brought to the High Court was appointment straight to the bar. Most High Court judges have been appointed after service on one or more other courts. A few have come from the ranks of the executive, politicians or Crown law officers. Fewer still have been academic lawyers. Since a golden era soon after the Second World War, when Justices Kitto, Menzies and Windeyer came straight from the bar, hardly any have done that. To have done so is an asset, although it's difficult to explain why. Is it because ex-private barristers have not been subtly brainwashed by colleagues in an earlier court, or having spent years resisting the large egos of aggressive opponents at the inner bar, are more inclined to work out problems on the bench for themselves rather than gullibly to trust their new colleagues? Or are they more immune from groupthink? Or have they not been rendered infantile or sophomoric by colleagues in an earlier court? Or do they lack any impulse to protect other judges? Or do they entertain no realistic hope of future promotion and therefore don't waste time currying favour with a view to securing it? I don't positively aver any of these possibilities, but I do say that there was in Justice Callinan no moral supineness or equivocation or evasiveness, and I submit that that stemmed, at least in part, from his appointment direct from the bar. His courtroom manner, and of course the quality of a judge depends partly on what is in the judgment and partly on proceeding in court, was impeccable. He was always immaculately dressed and presented. He exuded a massive physical force and solidity. He had an air of high seriousness. He spoke little, but when he did speak, he spoke in a noticeably quiet and measured voice, which compelled concentration on the substance of his thinking. Whatever he said in court responded to the arguments being put. There was no self-display, no meretricious cleverness, no showing off with false learning. In private, he was the most charming and amusing of companions, but on the bench, he abjured attempts at donnish wit. He didn't indulge in well-rehearsed spontaneities. He revealed a consciousness that the fulfilment of judicial duty created grave responsibilities for all judges and counsel involved, and a determination to ensure that his own were carried out. He listened to the arguments with faultless courtesy. He pondered them with a brooding sombreness. It was an error to conclude that he was enjoying the idleness of repose. He actually had a complete mastery of what was going on in argument, whether written or oral, and he was always well prepared without slipping into the vice of prejudgment. Before his appointment, Justice Callinan made it plain that he didn't think highly of at least some of the High Court's then thinking. He didn't ever display that attitude in open court or in judgments unless it was crucial to his reasoning. In private circumstances, it could be another matter. One afternoon, the late Bob Ellicott, an extremely able and experienced former law officer, federal minister, and federal court judge, then in his 6th decade of practice, was arguing a case on behalf of Nauru. With reason, he regarded himself as being very knowledgeable about Nauru, but his arguments were not well received. After the hearing, Justice Callinan and I returned to his chambers to find a live feed from the courtroom still operating. Ellicott, who was unaware of the live feed, was heard loudly expostulating with characteristic vigour to his juniors, "That is the worst High Court I have ever seen." Justice Callinan listened to this with amused silence, but there was eloquence in the silence. The increasing tendency of Justice Callinan to dissent or write judgments separately from members of a majority illustrates how much value he placed on the right to express his own views independently of others. He saw that value as outweighing the convenience, which is supposed to come, at least in the short term, from joining a majority. So over his decade on the bench, there is considerable bulk in his judgments. It's not possible today to do full justice to them. It's a common problem. You can see that from the hundreds of pages which American judicial biographers have to devote to analyses of the purely judicial work of their subjects. Take as an example a United States Supreme Court Justice who had much in common with Justice Callinan, and like Justice Callinan, his reputation is tending to rise as time passes. The judge in question is the younger John Marshall Harlan, named like his grandfather after the celebrated 19th century Chief Justice. Justice Harlan was a frequent dissenter in the United States Supreme Court from 1955 to 1971. His grandfather had been on the court from 1871 to 1911. The immortal but somewhat over-fastidious Mr. Justice Holmes, who sat with the grandfather for 10 years, called him the last of the tobacco-spitting judges. The grandfather famously called the Constitution colourblind in his dissenting judgment attacking racial discrimination in public facilities, a judgment which became the basis of the modern law in his grandson's time. The younger Harlan's biographer devoted nearly 300 pages to analysis of the judicial career and 100 to the rest of the life. What I propose to do is take a label which we heard this morning and examine the extent to which it fits. It's thought that the expression capital C Conservative was used by the late Deputy Prime Minister, the Honourable Tim Fischer, to indicate what general qualities he saw as required for a High Court judge in the late 20th century. He didn't mean it pejoratively. When Justice Callinan was appointed, the expression was taken over by largely hostile critics to describe the supposed traits of the new appointee and apparently contrast them with those of other members of the court. I have isolated 8, but there may well be more, of its possible meanings. None of them fit Justice Callinan. First, were the critics crass enough to mean that Justice Callinan was a Liberal National Party supporter who would compromise his legal thinking so as to advance the supposed political interests of those parties? If so, the falsity of the proposition is easily demonstrated. There were 2 cases of acute controversy while he was on the court. One was the Maritime Union case, in which by 6-1 the position of some allegedly locked out workers was supported. Justice Callinan assented, but the point of difference turned on a change in the law which the 6 justices had made in relation to the granting of mandatory interlocutory injunctions. It didn't turn on either side, it seems, on any particular stance that the government may have taken in relation to the union or the other party to litigation. The other case was at the end of his career, the work choices legislation. Justices Kirby and Callinan dissented, and their votes, of course, were highly favourable to the trade union movement, not the government. Incidentally, that last illustration shows, I think, that those who stereotype Justice Callinan as a capital C Conservative, who would doubtless not have stereotyped Justice Kirby as being one, are engaging in a rather useless process. The label is useless because there are many instances in which Justice Callinan agreed with Justice Kirby, or in which they joined together, or in which Justice Kirby praised Justice Callinan's judgments, or vice versa. A second meaning of capital C Conservative might be that the judge was hostile to the interests of the accused. He was not a Conservative in that sense. One can proffer many instances to establish his efforts to ensure the fairness of criminal trials. A third possibility is that he was Conservative in the sense that he wanted to deny relief to civil plaintiffs suing in negligence. There is no evidence for that either. He was perfectly liberal to plaintiffs and those whose interests deserved recovery, received recovery. A fourth meaning is a question of technique. It is suggesting, the critics are suggesting, he was employing only mechanical reasoning, operating by drawing inferences from premises internal to the legal system, not taking into account any practical or policy or values-based considerations. When one looks at the overall picture, that is erroneous. It is true that he disagreed with judges who chose to substitute their own perception of moral responsibility rather than concentrating on the actual words of a particular statute. But that is a different thing from the charges that were being made. A fifth possibility is that he had a very narrow view of an appellate court's powers in hearing an appeal. That is completely wrong. If anything, he had an extremely extensive view of an appellate court's powers in hearing an appeal, which was to some extent barred by the authorities, but that was not his fault. A sixth possibility is that he was procedurally a fuddy-duddy, tolerating undue slowness and complexity in the way litigation was conducted. That was erroneous. He favoured simplicity and directness and fairness in procedure. A seventh possible meaning was that he was opposed to the legal recognition of human rights. Now, human rights can be vindicated by non-constitutional sources of law or by the Constitution. His judgments show no signs of hostilities to the common law so far as it protected human rights. It is true that he disagreed with the Longy line of authorities, contending that there was an implied freedom of communication granted by the Constitution. His reasons for not accepting that line of authority rested on its total lack of support, either in the language of the Constitution or in the language of the judges who'd been applying the Constitution for the previous 80-odd years. Finally, in modern times, those who are harsh on the claims of visa claimants are sometimes called unduly conservative. Justice Callinan was not unduly harsh on visa claimants. In Singh and the Commonwealth, his dissenting opinion favoured one large class of visa claimants, namely those who were born in Australia to unlawful entrants. His judicial method, Justice Callinan's judicial method, was very largely orthodox. If one looks at his judgments, you will see they're organised by reference to the precise issues left by the time the case got to the High Court. He would set out the background to each particular issue, the arguments of the parties on the issue, and then he'd decide who was correct. He habitually applied, if there was an existing stream of authority, he'd apply it. If the outcome of his decision fitted in with the opinions of the profession, he saw that as a mark supportive of his view. If the outcomes supported the classes of persons affected by the decision, he would regard that as favourable to his conclusion. Let me conclude by suggesting perhaps that a better label for Justice Callinan than capital C conservative might be something like minimalist. I think it is true that he favoured doing no more than necessary. It might be a lot, but to do no more than necessary to achieve the result which the circumstances caused him to think just. So you can find examples of cases where the court's reasoning falls into three parts. A Justice Kirby, for example, in Garcia and National Australia Bank, offered a profoundly remodelled statement of the law applicable in the case. Four justices had a slightly remodelled approach. Justice Callinan simply took some remarks of Sir Owen Dixon in 1939, some cases that had followed those remarks, and said, they state the law, that's all that is necessary to ensure victory for the plaintiff. So, Justice Callinan had very fine qualities. Some of them have undoubtedly been shared by other judges, but taken in combination, those possessed by Justice Callinan made up a very unusual and even rare mixture. He fulfilled his judicial duty calmly, efficiently, faithfully and honourably. He was dedicated, businesslike and undemonstrative. He had complete integrity, commanding, straightforward and rugged. He had a clearness of perception, not fogged up by sentimental illusions. His independence is reflected in one desire which he did not allow to be obstructed. That desire was to work out for himself from the evidence and from first principles how justice according to law might be achieved in the case before the court, not in some other cases that might or might not come before the court later and that might or might not resemble the actual case under consideration. In that combination lay his significance in the history of the Australian judiciary. He defied the pessimistic predictions of his early critics. He showed that he could do things which they could not do. When John Millington Synge's play, The Playboy of the Western World, was first performed in Dublin, its run lasted a week, and every night there were Sinn Féin opponents of the play who rioted. To the critics of Justice Callinan can be applied the words which Yeats wrote about Synge's opponents. Once when midnight smote the air, eunuchs ran through hell and met on every crowded street to stare upon great Yuan riding by, even like these to rail and sweat, staring upon his sinewy thigh. UNESCO said, to think against one's age is heroism, but to speak against it is folly. Now, whether or not Ian Callinan was guilty of folly, the reception given to him by his critics has helped to start the process of recognising his heroine. Let us hope that as time goes on, the striking significance of his judicial achievement will be further appreciated. What his contemporaries could not recognise in him, later generations should highlight.